What, if any, type of collision is that data set consistent with, and why?
Yeah, there's a point there where it appears to be consistent with a pedestrian strike.
You did the reconstruction? It shows exactly how his body was positioned when he was struck by that.
So it looks like his arm was more kind of like this. I watched the video like after the report was done, and honestly I watched it first time on court TV. So
who on court TV during this trial?
You remember Trooper Joseph Paul. He was the crash reconstructionist who was beaten up by Karen Reed's defense during the first trial. So we're asking, will the prosecution call him this time? Plus, has Reed's support outside of the courthouse changed? A look at who's there this time around. Also this hour, a huge day for the Menendez brothers. The convicted siblings' resentencing hearing just hours away. And Diddy's judge slams Mark Garagos for calling the prosecutors in the federal case a, quote, six-pack of white women. From the jury to public perception, how big of an impact will race be in the music mogul's sex trafficking trial? It's all next right here on Opening Statements. Welcome to Opening Statements. I'm Julia Janae, filling in for Julie Grant this morning. Thank you for being with us. Just like in an actual trial, we are the beginning of the day. We're getting you ready for what's ahead in court. And it's time now for your daily docket.
Adelson? How you doing? I just want to give you this.
Can I ask you, is someone blackmailing you? No, it's always a possibility.
I said to Harvey, I swear to God, our family was cursed.
When did they issue a warrant?
One moment, Miss Adelson. Please keep your comments to yourself.
In Florida, matriarch Donna Adelson back in court for a motions hearing. Court is expected to begin there in Tallahassee at 9 a.m. Eastern. And in California, a resentencing hearing scheduled today for Eric and Lyle Menendez, set for 11:30 a.m. Eastern. And in Massachusetts, testimony resumes at 9 a.m. Eastern in Karen Reed's murder retrial. This is for the death of Boston police officer John O'Keefe. And that's where we begin today. Our top story, Sergeant Yuri Buchanan returns to the stand this morning for more cross-examination. Week 3 of Reed's retrial is closing in, and we're learning more about John O'Keefe's final movements. Let's take a look at that with Court TV anchor Ted Rowlands. He's reporting on the Commonwealth's cell phone timeline.
Prosecutors in the case against Karen Reed told the jury to look at John O'Keefe's cell phone for evidence of what happened the night he died. The location data, his movements recorded by a health app, and his cell phone battery temperature. According to the Commonwealth's timeline, Reed and O'Keefe arrived at 34 Fairview Road and parked near a flagpole at about 12:24 a.m.
At 24 minutes and 38 seconds is the first record that shows a speed of 0 meters per second.
Karen Reed and John O'Keefe allegedly stayed in the car for several minutes, while Jen McCabe texted O'Keefe from inside the home.
John O'Keefe was in that car, that Lexus, and didn't move because his healthcare data is not moving. At 12:31:56, he begins to move. He will have 20 seconds before he falls.
Prosecutors say cell phone evidence shows that John O'Keefe got out of the car, looked at a text from Jen McCabe, and then put the phone back in his pocket.
At 31 minutes and 56 seconds, we start the health event that shows 36 steps were taken. The message, "Pull behind me," is read. 32 minutes and 9 seconds, the message's application is closed, and the device is locked for the last time.
Prosecutors allege John O'Keefe's phone shows that seconds after he got out of Karen Reed's vehicle, she backed into him and left him in the snow. Their evidence? John O'Keefe's movements stop and his phone begins to drop in temperature.
32 minutes and 16 seconds, the 36-step health event is ending. 37 minutes past midnight, battery temperature has dropped to 72 Fahrenheit. 43 minutes past midnight, the battery temperature has now dropped to 66 degrees Fahrenheit.
Investigators say O'Keefe's cell phone was in his back pocket while he lay in the snow, and by 1:15 a.m., its battery had plummeted to 50 degrees. Prosecutors say when he was found and moved, the cold air hit the phone and it dropped again. to 37 degrees.
Then you're now at 6:14 and it's 37 degrees?
Yeah, you're correct. This is the coldest temperature recorded.
So this morning, we are talking about the data in this case. The electronic data is so important, not just the phone, but also the data from Karen Reed's SUV. And last year, this is the man who helped the Commonwealth share that information with the jury. This time around, they have a PhD, a Dr. Judson Welcher, who's going to be testifying. But we're asking the question, will the Commonwealth this time around also call Trooper Paul? He faced some scrutiny, especially on how he was handled on cross-examination. Let's take a look back at one of those moments.
So the tail light in this case was shattered when it was struck John O'Keefe's arm.
Exactly what part of his arm?
Based on what I saw for his injuries, was from the upper part of his arm down.
Was his arm out? It just struck the arm like a hinge? Was it in front of him? You did the reconstruction? It shows exactly how his body was positioned when he was struck by that.
So it looks like his arm was more kind of like this, if I can try to get that.
All right, let's bring in our guests who are here to discuss criminal defense attorneys and former prosecutors, both of them. So good to see these two, David Bruno and Joe Tamarino. Thank you both for joining us. David, let me start with you. Do you think the Commonwealth should call Trooper Paul when they do have another accident reconstructionist expert who we expect to testify?
Oh, Hank Brennan's coming in with a different presentation. We may not see a Proctor. We may not see the accident reconstructionist, because both of them are liabilities for the Commonwealth without a doubt. So as far as, Paul, he could possibly be replaced with that PhD if all of his testimony was of expert opinion. Because expert opinions really are just reviewing the evidence and coming to their own opinions based on the evidence. And really, he got rocked on a number of things on speculation, including specifically the flying through the air 30 feet, the body of John O'Keefe. So if Hank Brennan can, he certainly will try to avoid Trooper Paul for that reason, because they did in the first trial. The defense did a great job on cross-examination. It was one of the highlights of their attacks, and certainly him and Proctor would be the best way to go about it by Hank Brennan, by avoiding those two witnesses.
Oh, David, you brought up a good moment from the last trial. That was that cross-examination, the flying through the air, where Alan Jackson said, was it like a pirouette? Oh, when it comes to John O'Keefe's body in the air and trying to visualize that, what do you think, Joe? Should they bring in Trooper Paul as well, or should they just stick with their expert, who's going to be a little bit removed? He is going to not have looked at this evidence until after the first trial, versus a trooper who would have been more closely connected to the scene.
Thanks for having me on, Julia. No, I don't think they're going to call Paul. I mean, he was disastrous in the first trial. And I think it's better to have a new expert, because not only do you get to view all of the evidence that originally was there, but you get the benefit of reviewing the first trial. I'm sure this expert went over what Paul said in the first trial. I'm sure he watched segments of it on TV. I'm sure he's looking at the transcript. So he's in a way better position. And this is just another example of Mr. Brennan doing just a totally better job than the first time with Mr. Lilly as a prosecutor. I mean, Brennan's changed everything up. The way he started the trial with Mr. Nuttall as a first responder, that was great. The way he's not calling Proctor, that was great. The way he puts in evidence, like all the clothing and the plexiglass, that was great. He's doing so many things much better.
Oh, yeah, the clothing and the plexiglass, that's one of my first times even seeing evidence being presented to a jury like that, almost like it's in a museum, but I think it is helpful for the jury to see it that way. Let's take a look back, though, at some of what Trooper Paul did tell the jury the first time around, because we are going to hear that at some point, whether it's through Paul or through Felcher. Let's listen.
So the vehicle was traveling in reverse.
And how fast was the vehicle traveling and over what distance?
The vehicle traveled up to 24 miles per hour and approximately 62 feet.
What, if anything, occurred then?
The the right rear of the Lexus struck the pedestrian John O'Keefe.
And post-collision, what, if anything, occurred with regard to Mr. O'Keefe?
Mr. O'Keefe was projected forward and to the left along the front yard of 34 Fairview Road.
David, let's talk about these details because this is where some people get stuck. We have a reverse motion. There is a triggering event in this CDR box or black box from the SUV of Karen Reed. 24 miles per hour, 60 feet traveled. What do you think jurors are going to have in their heads when they hear that? Does it sound plausible to you?
Well, look, putting the Reed vehicle in reverse is a good fact for the prosecutor, without a doubt. The problem becomes the lack of damage on the vehicle. It is limited to the lens, the covering glass or plastic of the taillight. And then the projection, like I said, this 30 feet plus projection of the victim. And that's where it gets a little gray. And that's where Trooper Paul had most of his problems, because that's really speculation. I mean, Jackson did a great job in the first trial of really laying out where the plastic was found and then where the body was found and then tying him in that way. So I agree with Joe in the sense that the next expert coming in is going to be ready for the attacks. It already appears that they're trying to clean up the problem areas. Specifically, we saw it just recently, too, with the Google searches of Jennifer McCabe. The 227, that's a tab that was started at 227. That's not the actual search. That was later after 6 a.m. Hank Brennan knows where he's got to clean up, and certainly this speculation about the flight as well as the lack of damage to the car and those injuries to the arm are going to be an area that the defense is going to attack, and Brennan's going to be possibly ready to explain.
Yeah, those injuries are a big issue because no visible injuries other than the arm to his torso, to his abdomen. So it leaves a lot of people wondering, Joe, where's the injury to his body if it happened the way Trooper Paul said and what we expect Dr. Judson Welcher to say there on the stand?
Well, I don't think, I mean, we know that there weren't those type of injuries to the body, and I agree that a lot of it was speculation, but I think that's going to get cleaned up now because, you know, at the end of the day with all of this, and I said this from the very beginning, I never thought this was a murder trial. I mean, this is a vehicular manslaughter trial. This is a DWI where you hit somebody trial. And even though Mr. Brennan is doing a fabulous job, I still think at the end of the day, that's what it's going to come down to. So did he need to have all these type of injuries on his body? No. To prove this case, especially with a vehicular manslaughter, all they got to do is show that these people were drinking, that she negligently backed into him, which is consistent with the injuries that he has, and it's consistent with the taillight, and it's consistent where he was found, and she might not even have known when she drove away that she actually hit him.
Oh, yeah. You know, you talked about this being a different trial, different feel overall. I'm wondering if the demonstrative aids are going to be different, and we'll see some type of animation of what the prosecution's theory is so that jurors can really visualize it and compare it to that jury view that they went on. David and Joe, you all are sticking around. We've got to get to a break, but still to come, our coverage of Karen Reed's retrial isn't over.
Karen Reed! Free Karen Reed! Free Karen Reed!
Are people still #Reed Strong outside of the courthouse, and how the possible change in support this year could tip the scales in her case? Plus, a much anticipated resentencing hearing for the Menendez brothers scheduled in just hours. What can we expect? We're talking about it this morning.
Is Karen Reed a killer girlfriend?
She's guilty.
Or the scapegoat in an elaborate cover-up?
Karen Reed was brave! We know who did it.
The Karen Reed murder retrial. Live coverage today on Court TV.
Just look at that touch from Trinity Rodman.
Saturday night.
When she is on the field, she changes the game.
Saturday night.
Saturday night is our night.
The new Saturday Night Out is on ION all season long.
Can you answer the question?
Yes.
Okay, was you telling Lyle what?
My dad had been molesting me.
There was no reason to lie.
clearly he was coming to me, wanted me to do something about it.
I came to a place where I believe that under the law, resentencing is appropriate.
I would be doing a disservice to the Menendez brothers, to the victim families, to the public, if I do anything other than a thorough review of the facts and the law.
Now for what's trending in true crime. A hearing in the long-awaited resentencing for the Menendez brothers is scheduled for today. Eric and Lyle Menendez have been waiting for a resentencing and being in this process for months now. Today, the court is expected to consider the admissibility of the brothers' risk assessments, which were ordered by California Governor Gavin Newsom. And the defense is going to make their case that the district attorney who's in charge of this office now, Nathan Hochman, that he should recuse himself from the case.
Mr. Hochman taking positions and doing press stunts that, in my humble opinion, not only violate his duty to the law, but violate his duty to the state of California, the county of Los Angeles.
You may remember the brothers were sentenced to life in prison back in 1996 for the killing of their parents, Jose and Kitty Menendez. And this morning, we are asking what we can expect out of today's hearing. Let's bring back in our panel of guests, criminal defense attorneys David Bruno and Joe Tamburino. And joining us now, law enforcement expert Sonny Slaughter. Good to have you all along. David Bruno, let's start with you. What do you expect out of today's hearing in this lengthy resentencing process? It seems like it's gone on for months.
Yeah, you laid out the two primary issues well, and that is the court going to consider this comprehensive report by the parole board? You know, it was last time we were in court, it was like, hold up and stop, we have additional evidence. And at that point, we didn't know if it's coming in or not, and we still don't. We have not been given any hints one way or the other. I assume it's probably good for the DA, because the DA is the one that wanted to admit this in that late hour. And then that second point where Garagos is trying to get Hochman recused, I don't think that's going anywhere, honestly. This is somebody that was elected, brought in. He's going to make the arguments. The judge is going to call it. And then final point, this is the judge. I mean, the DA withdrew this motion. The judge didn't have to take this. He could have withdrew the motion just like the DA did, but the judge on his own authority kept it up. So I know a lot of people don't think it's going to happen, the resentencing, but that's the glimmer of hope that the Menendez brothers have, in that this court did allow it to continue.
So there is a chance that they could get a resentencing, which many have said would mean they could get out on parole immediately. I want to take a look before I ask you a question, Joe, at the family statement. So the Menendez family, they've been supporting Lyle and Eric Menendez, all but really one family member. And they had this to say in advance of this hearing. They said this motion, their motion to recuse, is about accountability and ensuring that Nathan Hochman's office stops crossing ethical lines and starts respecting our rights as victims under Marcy's law. It also states that the DA's office may think that we blindly decided to forgive Eric and Lyle, but our journey to forgiveness was not linear. It's a direct result of the men they have become. Joe, do you think that when we have this district attorney who they say is blocking them, but comparing that to George Gascon, who was supporting them, do you think they have a case there in front of the judge?
No, not at all. I mean, I could be wrong, but I don't see any of this going anywhere. Hochman will not be removed. The judge will allow the risk assessment. There's no doubt about that. And the judge is not going to resentence. I just don't see any of this happening. And this whole idea beyond that, you know, Gavin Newsom, the governor, in the last resort might, you know, commute their sentences or something like that. That's ridiculous. That's not going to happen either. I mean, Gavin Newsom is likely one of the individuals who will run for president the next time for the Democratic Party. There's no way he's going to do that. So, short answer, Hochman's not going to be removed. The study's coming in, and the judge is not going to resentence.
All right, there you have the prediction from Joe Tamburino. Sonny Slaughter, your thoughts on the family statement where they believe that this district attorney's office really is blocking them, violating their rights. And they even say that he demoted people, and those attorneys also say that they were demoted because they supported the Menendez brothers there in his office.
Good morning, Julia. Good morning, everyone. While I think all of the family statements are important, I think that the risk assessment is coming in. It is a critical piece. It is not new to the Menendez. It is not new to what we do in criminal justice systems, so it is not new to this particular case. It has critical information. If that information is negative in any form or fashion, as to public health and safety risks, then the judge is absolutely going to consider it. And I'm not sure whether he's going to take this as a resentencing assessment, as this assessment to make his decision around resentencing. I think it's a long shot, but I do think they do have a shot. And I think the family is still going to support their loved ones. But that is only one part, because the public risk is greater than what the family's concerns are and their potential rights regarding this matter.
Yeah, let's talk about that public risk. Let's listen to what the governor had to say when asked about that specifically.
There's no guarantee of outcome here. My office conducts dozens and dozens of these clemency reviews on a consistent basis, but this process simply provides more transparency, which I think is important in this case, as well as provides us more due diligence before I make any determination for clemency.
And David, how big is it that the public know about this risk assessment? Is it common for the public to know about what a risk assessment says before someone may be released? And how do you think that plays into a case that is such a high-profile one like this one?
No, it's not common that the public gets this information. I mean, this is parole at its best. I mean, parole's there to determine whether or not the inmates are able to go back into society and be released safely. Now, what Joe said is important here, and I guarantee that there's been polling from that particular video by Newsom, because this is a hot button issue for politics. And if he does want to get into the presidential race, this is going to be one of the issues where he's going to be seeing where it is on the public spectrum and where it's falling. And I guarantee that his people have done polling on that particular video to see where his constituents are on this point.
Joe, let me ask you this about what Nathan Hochman wants, because he says all he wants really is contrition. He wants the Menendez brothers to fall on their sword, to admit their lies, to admit that the defense that they had back in the 90s was a fake one in terms of self-defense, and show full remorse. The family says these brothers have shown remorse, but Hochman wants it on the record. Do you think the defense should think about this and try and do something to appease him in order to get this resentencing on a more positive path for them?
Yes, I agree. The only path forward for the defense is some type of redemption by saying, you know what, regardless of what our father did, you know, we were completely wrong. Forget about our prior two trials. We should never have done it. We should have pled guilty. I mean, things like that. And I bet you some of that's in the risk assessment, but really that's the only path forward. However, the defense isn't doing that. They've doubled down on the whole abuse situation. They're saying they've got the letter, the infamous letter. They want to have a new trial. That letter should have been presented to the second jury, all of these things. So yes, the defense should be doing a redemption, meaning, you know, we have changed, we have seen the evilness that we've done, but they're not doing that. They're basically saying, we were abused, look at this letter, the second trial wasn't fair, we should have had more evidence in about our abuse, so on and so forth. So, yes, I agree, they should be doing that, but they're not.
They're not. Just a real quick follow-up before we have to get to break. Joe, do you think there's a reason why they're not doing that? Do they think that it's a lose-lose situation?
Yeah, well, they're probably getting legal advice. I mean, that's what I would imagine. That's what an attorney's for. You sit down with your clients and you say, what's the best path forward? And they've made a determination as a team that the best path forward is to continue to fight along the lines of, we were victims of our dad's sexual abuse.
We will keep you updated on what happens in that hearing. 11:30 Eastern is when it starts there in California. Our panel of guests, they're sticking around with us. We're going to get to a quick break, but coming up, the jury is expected to be finalized today in the Diddy federal sex trafficking trial in New York. And we're asking the question, how much is race going to impact his trial? And before we go to break, here's another quick trending story, a bizarre court appearance from actor Jennifer Aniston's alleged stalker. He appeared in a Los Angeles courtroom shirtless, wearing nothing but a blue blanket around him, and the judge ordered the man to go through a mental health evaluation to see if he's fit for trial. He's charged with felony stalking and vandalism after allegedly crashing his car through the front gate of Aniston's home. We'll be back after this.
It's so difficult to reflect on the darkest times in your life. Sometimes you gotta do that. I was disgusted then when I did it. I'm disgusted now.
As alleged in the indictment, to carry out this conduct, Sean Combs led and participated in a racketeering conspiracy that used the business empire he controlled to carry out criminal activity.
Parties are convening this morning to get a jury seated in the federal sex trafficking trial for Sean Diddy Combs. They are going to be sworn in on Monday. There's a pool of 45 potential jurors, 50 that the court were able to identify, that the prosecution and the defense are going to be exercising their strikes to get that number down to 18, which includes 6 alternates. But there's this visible undertone for the case, and it's the effect that race could play during the Sean Diddy Combs' trial, including the makeup of the prosecutors, not just the jury. And it's a topic that famed attorney Mark Garagos, who we just saw when we talked about the Menendez family, his daughter is on Diddy's defense team, Tenny Garagos. And Mark, on a podcast with Harvey Levin, Two Angry Men, had this to say.
So 6 women, all white. All white.
Correct. That's my understanding. I've only seen a couple of them, or know of a couple of them, but my understanding is that you got a 6-pack of white women.
That's not coincidental.
But I'm not so sure that the defense is going to center so much on the race. That may be an undercurrent, as it always is. I'm the first to tell you that based on doing this, going into my 5th decade in the criminal justice system, that race underscores everything in the criminal justice system.
That's what Johnny Cochran said.
So you heard there the comments that actually really raised the ire of the prosecution in this case. They asked the judge for an admonishment over it, and the judge did tell Garagos to further exercise caution. This was back in February, though, what we're looking at in terms of what the defense has filed. So that comment about 6-pack of white women on the prosecution team, something that the judge said was outrageous, was not happy about. But let's take a look at how race might impact Diddy's trial, because this is a defense filing from February where they said this case is unprecedented in many ways, and perhaps most notably and most disturbingly, no white person has ever been the target of a remotely similar prosecution. Sean Combs is an extraordinarily successful artist, businessman, philanthropist, and one of the most accomplished black people in this country. And that motion to dismiss goes on to say that Mr. Combs has been singled out because he's a powerful black man, and he's being prosecuted for conduct that regularly goes unpunished. Count 3 in the indictment should be dismissed because this case is clearly selective prosecution. So as we inch closer to finalizing a jury, it's happening today in New York. We're wondering how much is race going to impact Diddy's trial? And to talk about this, let's bring back in law enforcement expert Sonny Slaughter. And joining us now, jury consultant and human behavior expert Susan Constantine with us as well. Susan, let me start with you. Do you believe that race is going to play a factor when they are picking a jury? That's going on now. How much do attorneys consider race when they are looking at a case similar to this one?
Well, they do. In fact, when I began my career with working with JuryQuest, out of the 7 demographic factors, race was one of the big ones. So if you remove race out of it, it would skew actually the point system in which I used in profiling a juror. So adding race into it, especially a black juror, would actually sway more towards the defense. So the defense always is looking for often black or minorities within their jury pool. So it really can. But keep in mind, as a really ethical trial consultant, we have to have a blend, right? So we don't want to play into the racial bias. We don't even want to play that game. We want to keep the jury more neutral. But unfortunately, the game plan is to stack it in their favor. And that is what I personally have an ethical issue with. When you're talking about seven white, prosecution pack.
And Sonny, let's talk about that because, well, we'll talk about the prosecutors in a moment. I want to talk about the issue that the defense put in their motion to dismiss. Mark Garrigo saying, hey, I don't believe that it's going to be front and center in the trial. It may be an undercurrent. He is not on the defense team. He's connected to his daughter, who is on the defense team. But do you think it should be an overarching theme? Should we get opening statements in front of a jury and have them say he is being unfairly treated because of his race?
Julia, I think we should get the statement in front of there, but is he truly being unfairly treated? When you think about the extensiveness of the actual crimes and who the victims are, is he being unfairly treated, or does this case meet the measure of the law? This case was investigated by Homeland Security Investigations. Homeland Security Investigations are the top law enforcement investigators specifically on human trafficking cases. They have investigated this case. I know they have done it over an extensive period of time and the information that they have. So if the defense thinks that they have some game with what the law enforcement has done in this case, I say game on, bring it to the forefront, let's have it out. The prosecution team is the prosecution team. They are highly skilled. This is not their first rodeo on this, and let's make it do what it do and stop getting sidetracked by race, because this is an issue of SA and what happened to the victims.
And Susan, I know you can speak to the fact that if attorneys are caught trying to get rid of all but one race on their jury, they could face a challenge. Let me, though, show you one of the demographics that we know of a potential juror who is in that pool, who may be on the panel. They don't tell us the race of these jurors, but from the conversation they had with the court, here's some details on one. He's a male in his 30s, in a historically black fraternity, listens to rap and R&B music. That's something all of these jurors were asked about, their music preference. And he said he did retweet a meme about Diddy since the allegations happened. Let's start with that one, Susan, and just tell me if he's someone, if you're the defense, that you do want on your jury, even though he did retweet there something about the Diddy allegations. So I'm not thinking there are any memes out there that are actually pro-Diddy that I've seen.
Well, on the surface of it, yes, for the defense, but that's not everything. Just demographics are not the number one element that we look for. We're looking about behavior. We're looking for attitude. And what I would be doing, now this is a juror they're considering as a defense juror, okay, or maybe the state to strike them. I would be looking at all of their posts, right? What are they posting? Who are they hanging out with? What are the photos that they're posting? What is the story they're actually telling? So that will give you a little bit different insight into their values, their belief systems, their lifestyle, et cetera. And this case is all about lifestyle changes and that alternative lifestyle. So if I were on the defense, I'd be looking for those alternative lifestyle persons. On the state, I'll be looking for more of those conservatives.
I want to go back to that screen we were just showing, Sonny, so we can talk about a second potential juror we pulled out. This is a woman who's in a historically black sorority, listens to contemporary Christian music and R&B. She watches CNN for her news, and she's a teacher. We heard those comments by Mark Garrigos talking about the racial demographic of the prosecutors, but they are also all women. Do you think that the prosecution should be considering that when they are picking their jury in terms of a woman being on the jury and listening to the details that we're going to hear from these victims who are going to be on the stand, alleged victims?
I think they should absolutely be thinking about women of color. This case has divided so many people based on race, but I think it is important to have a large number of women on this on this trial, but we also have male victims. So those women need to have views that focus on victimization, not just gender, and how it impacts them. I think we should consider all of the factors. And I think having a large number of women, having women of color, not just Black, African American, but other minorities, to have a diverse jury pool. We want a jury of our pool, of our peers, but what type of jury does Sean Diddy Combs have? Do we want people that will let him go just because they look a particular way or because they listen to his music? I've listened to Sean Diddy Combs' music. Am I a person that you want on the jury? Maybe, maybe not, because you want somebody that can have unbiased opinions.
Susan, is age more of a factor that we should consider when looking at this case? Here's another potential juror that is 71 years old, works for an African-American dance company, listens to classical music, and told the court they were initially unsure about discussing sexual topics with strangers in deliberations, but after more questions, did tell the court that they could be fair, they could handle it. When you're hearing those details, and I noted what you said about the alternative lifestyle, that's certainly going to be something the defense is going to be arguing. These freak-off parties, this is just part of his celebrity lifestyle. Don't hate him because you ain't him type of argument. What do you think about age being a factor in these attorneys picking their jury?
Absolutely, age is going to be a part of it because it's what they were brought up with. So at 71 years old, this person was not raised or really probably turns on, the rap music. Probably can't relate to it. So in essence, when we think about it, if you're looking for a fair and impartial jury, that person may say, hey, I can set aside my own upbringing, look at the facts and the evidence of the case and make a decision. But however, that 71-year-old is not going to be able to be unbiased when it comes to these lifestyle choices and might be appalled by it. So I'd be looking for those jurors that might or show any sort of disgust or disdain regarding that lifestyle. So the older ones are probably not the best for Diddy. I'd stay with those younger and middle-aged individuals, male or female.
Oh, we certainly appreciate your insight on that, Susan Constantine. Thank you for being with us. Sonny Slaughter, I understand we have to say goodbye to you as well, so thank you both for being here. We will bring you the latest on what is happening out of New York today in the Diddy trial and let you know when that jury is seated. Opening statements will begin on Monday. Coming up here on Opening Statements next. Those are images from Karen Read's first trial last year, and we're wondering, are people still #ReadStrong?
It's been my passion to work in nursing homes.
One of our residents passed away.
On the next Interview with a Killer.
You watched and stood by while your patient was lying there being tortured.
What else was I supposed to do?
That's so conniving. You understand that? So much for your career in caretaking.
Interview with a Killer, season finale, Sunday at 8 on Court TV.
We're not putting up with that. We're right here today, Jim McDermott, and we're not going to be quiet. We're here. We got it.
Now for what's tipping the scales in Dedham, Massachusetts. Has there been a change in public support for Karen Read? You just saw what the outside scene was like at Karen Read's last trial, 2024. The public was loud and out in full force. And compare that with what's happening more recently. They have been moved back many, many yards further back than they were last year, and it doesn't seem to be as quite the same wild scene. She still has support, but has that support subsided, and could that ultimately tip the scales at all in her case? Let's bring back in our guests who are standing by. Former prosecutors David DeBruno is with us and Joe Tamburino back with us. And I want to know what you think about the outside impact of those supporters that are there? First of all, have you been wondering what the support is like? Joe, let me start with you.
Yes, I think it's going to have some impact. I don't know how great it would be. I mean, we're all human beings. Jurors are human beings. So you can tell when all of a sudden there's, a groundswell of support, people protesting for something or against something else. So sure, having people outside of a courthouse does have some impact. However, I think the judge is absolutely right. You have to have a buffer zone. You can't have all these emotions trying to sway a jury. So I think by having these protesters so far away from the courthouse is going to help the prosecution.
And David, I wonder if that buffer zone is what may be impacting the amount of people we're seeing out there, because they're not in the thick of it. They're not right there with Karen Reed. They are 300 yards plus back. Do you think that will impact it? And could it impact how things go with an outcome? If this is guilty, not guilty, or hung, does the subsiding perhaps of support there on the outside indicate anything?
Yeah, I do believe that the enhanced buffer zone has caused the diminished people there. Because I'll tell you what, I mean, digitally, there is a strong presence still. I see it in my social posts. I mean, this time around, Hank Brennan, I think, is doing a much better job. I thought they did a better job with the forensics on the Google searches, potentially not calling Proctor. So I'm out there, commenting, trying to give it straight, and I'm seeing those people still in the comments. With that being said, this should not have any bearing. These jurors have a very difficult job. They have to determine their verdicts based on the presentation in the courtroom. And again, last point, I do think the Commonwealth's doing much better. Proctor's going to be at issue here, though. I don't think he's coming on the stand. That could be a mistake for the Commonwealth because he's been terminated. The change of circumstances just on that termination alone, and that Jackson and the team want to get that out and continue to push the buttons on Proctor, and it may even embolden the defense in that courtroom if Proctor doesn't take that stand.
Oh, absolutely. He's such a wild card in this case and such an important factor. And I agree with you that online, the social media support for Karen Reed, if anything, has gotten more voluminous in terms of what I see underneath my posts as well, or Court TV's post. Let's listen to some of those supporters from last year, how they sounded, what they felt before we actually got a non-verdict in the case.
I thought Alan Jackson was incredible. I want justice for John O'Keefe after this is done.
It's about justice, and it's about the fact that anyone can be charged inappropriately. Anybody could have this pinned on it.
We stand for the O'Keefe family. We stand for John O'Keefe. This is an abomination what's happening. They're treating this like it's a recreation, like it's a murder trial. Like it's a propaganda campaign to get her out. And she launched that FBI investigation and caused reasonable doubt. That should have never happened.
How do you feel about the hung jury today?
I'm glad it's just not guilty, so we'll see. Hopefully they come to a decision.
And you can say with confidence you think
100%. She admitted it.
Now, you heard there at the end, those were the counter-protesters last year, Joe. People who felt they needed to come out and support justice for John O'Keefe in opposition to the Karen Reed strong supporters. Tell me your thoughts on what is going to happen going forward in terms of Michael Proctor, whether he's going to be testifying or whether or not we will get a verdict this time around.
Well, a couple of things. First of all, I still don't get all these protests. I mean, I just got to tell you, this is not the trial of the century. This is not, something like George Floyd or anything like that. I mean, this is your common, to me, run-of-the-mill criminal vehicular homicide cases that are going on in our country all the time. I can't tell you how many cases I've had like this, where you have the allegations of someone drunk, someone driving a car. So, I mean, and I don't think Proctor, just to answer your question quickly, is going to testify.
Joe Tamburino, thank you for your comments. David Bruno, I know we have to say goodbye to you. Thank you so much for your analysis. Joe's coming with us. That's it for opening statement.